if you're over 18, you own anything with a deed or a title, you have a child, or you're married, I believe that you need to have a will.
Well, it's time for another edition of the Financial Puzzle Playbook podcast with your host, Jim Sumpter. I'm RJ Malik, producer of this podcast. And Jim, as always, great to see you. And what do you got lined up for us on this edition?
Well, RJ, first of all, it's great to see you again. Hope you are staying cool during the national heat wave that we've had. We have certainly had our fair share in the South. So hope it's at least somewhat cooling in the Northeast a little bit. So
it's starting to, yes. And I had to call my sister down in Florida when we were hotter than they were.
Yeah,
she laughed at us.
Yeah, because the thing is, the people in the Northeast, I love it. When they say, "Oh my gosh, it's so hot." Well, how hot is it? Well, it's like 84. It's like, "Oh my gosh," It's like, hey, come to the South where, it can get, 98 degrees and 98% humidity.
Yeah.
And then tell me about how hot it is.
No, thank you.
Yeah. Well, RJ, today, speaking of hot, we're going to actually talk about a hot topic that has come up quite a bit in my practice over the last 3 or 4 months. And, we're going to jump to the end of the puzzle, if you will. And I want to talk about estate planning, which is, not the most glamorous topic that we have, but I want to remind the audience about a few things, a few basics of estate planning. So what we're going to do today is we're going to cover, who is it for? Who is it not for? Why is it important? When do you start? How do you start? And then there's really 3 main documents that I'm going to touch on. And then I'm going to end on beneficiaries and the importance of that. So that's really where we're going to head. In this whole episode today. But so let me ask you this. Have you done any estate planning?
Embarrassingly, no.
Okay.
That's a discussion my wife and I have had a number of times over the last, I would say 3 or 4 years. And we keep putting it off. And it's my fault. It's my fault.
So let me ask you this, because you said we keep putting it off. Procrastination is the number one reason that people don't do estate planning. And why do you think that? Why do you think that is? Why is it that, in a general sense, 30,000 foot view, why haven't you done anything?
I think it's just something that you have to do, and it's important. Without a doubt, it's important, but it just seems like it's an arduous task that you just have to be in the right frame of mind. And at this point in time, especially during the season, the summer season, when it's a choice between sitting down and talking about your end of life stuff and going to the beach.
Right.
The beach wins all the time.
No, I 100% understand. I'm gonna take a couple of things that you said, some of the what I'm going to call misconceptions, and that's what we're going to talk about today.
Okay.
So let's kind of jump into what is estate planning, and it is not for someone that has $15 million all of the time. Now, if you have a lot of money, and I use 15 million because a lot of people know that number, that's a unified credit that every person in America has under the current rules. This number has changed over time. It has shifted over time, and Congress sets the number. Okay. As part of the tax code, part of the estate tax code. A lot of people feel like, well, I don't need to do estate planning because I don't have anywhere near that amount of net worth. And I would argue that is not exactly correct. I would argue that anyone that is married, that owns property, that owns personal property or things, or has a child and is over the age of 18 needs an estate plan. And so we're going to jump into what does that actually look like. Now, I said a whole lot of things in there that most people would fit into one of those categories. Here's what's interesting. There's study after study after study. One that I read recently is that over 50% of the people in this country don't have any sort of estate documents.
That doesn't surprise me. I had to say that.
Yeah, yeah. Well, and like I mentioned, procrastination tends to be one of the number one reasons. Cost tends to be one of the reasons. And then something that you mentioned is that you feel like it would be a very arduous process.
Right.
And so I'm going to talk about a solution that, towards the end that may be a way to help, some people and some listeners to sort of get through some of this process. But, let's talk about, I mentioned 3 documents. I'll start with a will, because everybody thinks, okay, well, I need a will. I don't need a will. I don't have anything that would go through a will, or everything goes through a will. Let's talk about what a will is. So a will is a document. It is a legal document. Now, in disclosure and in disclaimer, I'm not an attorney. Okay. I am, however, a financial planner, and I have read through a lot of will documents, trust documents, things like that. But I'm not an attorney. So what I would encourage people to do is make sure that whatever state you reside in, that your legal documents that we're discussing are applicable to your state. So for example, if you live in one of 9 community property states, you want to make sure that your legal documents have community property language in them. If you have ever lived in one of those 9 community property states, you want to make sure that your documents have that type of language. So where are they? I'll start east to west. It's Louisiana, Texas, New Mexico, Arizona, California, Washington, Idaho, and Nevada and Wisconsin. If I mentioned those states and you've ever lived in one of those states, there is a potential that you have community property. If you live in one of those states today, there is a potential that you have community property. So it is important to understand, what does that actually mean? What does that actually look at? And it has to do with spouses and the way that you would own property with a spouse. The second thing that a will does is a will is going to name an executor. What that is going to do is be who is the person that is going to be put in charge of your estate. It is not a glamorous job. I will say that first and foremost. But who is the person or persons, because you could have a co-executor that would be in charge of your estate when you pass away. A lot of people think, well, it's going to be a long time from now. Nobody wants to think about, passing away, their death. So they say, well, I'll get to that. I'll get to that later. The thing is, we never know when that could happen, or you could become incapacitated. And as long as you're alive and competent, you can create a will. Once one of those 2 things happens and you become unalive or you become incompetent, you no longer have the ability to create a will. So you're going to name an executor. You're then going to name who gets your stuff. Okay. That could be an individual. It could be a group of individuals. It could be your children. It could be your siblings. It could be your parents. It could be a charity. It could be a variety of things, and not everything has to go to the same person. Well, I will mention one of the biggest misconceptions that I think people have is that, well, I've got my will in place, so that means that my 401k at work or my IRA or my Roth IRA is going to go exactly as my will says, and that's not correct. When we get to beneficiaries in just a little bit, we will address that. but the will is going to cover anything that does not pass by ownership or beneficiary. Then it goes through a will document. And that's how things get passed down. Now, RJ, you mentioned, and I think you live in New Jersey, correct?
Yes.
Okay. And I'm sure that you love every decision that the powers that be in the state of New Jersey and the county that you live in, you love everything about everything that they do, right?
Maybe not everything.
Maybe not everything. Okay. So you mentioned that you don't have an estate plan. You actually do have an estate plan. And your estate plan, because you don't have documents, is that if something happened to you and your wife, then the state of New Jersey and the county that you live in, they would get to decide, the probate judge in your county would get to decide where all of your stuff goes. Now, there are some guidelines, there are some state guidelines that it would pass, to your next of kin. Well, what is your next of kin? Well, your state is going to define that. And this is where a lot of times things get sort of, out of whack, if you will, because whereas you may want it to go to one particular place, you don't have anything that says that. And you say, but my family knew that's what I wanted to do, but it was never written down. Or you say something like, well, I had it all written down on a legal pad that was in my, on my vanity or in my drawer. And can't they just find that? Well, that document has to be notarized and witnessed, or it's not legal. Okay. And so that's important to make sure that process has gone through. Now, does an attorney have to be the person who actually sets that up? And in today's world, the answer is actually no. There's some online resources where somebody can go and create a simple will. There's some AI tools that are available. Sometimes advisors can help guide clients through making some of those decisions. Still the client's decision, but they can help guide through. Or you could have an attorney. You probably don't want to have your brother-in-law, but I mean, I guess if he could write it all out, you have it notarized and witnessed. That technically could be a will, but it is a written document. That's the first thing I want to pass along. And so the will names an executor. It names who gets your stuff. The other thing that it does is if there are any trusts that are being created, it would create the trusts. It also could do something that is very, very, very important if you have children that are still minors, and that is it creates guardianships. I have had so many families that I ask them the question, Mr. and Miss Klein, if something happened to you, who would take care of your kids? And one spouse says, well, my mom would take them. And then the other one goes, well, no, that's not going to happen because my mom would want them, or my dad, or no, I want them to go to my sister. Well, I don't trust your brother-in-law. Why don't, and so you get this back and forth and back and forth. And that is one of the reasons that a lot of things don't get done is because so many people have a difficult time making decisions on who would actually be the guardian for the kids, who would actually be in charge of the money for the kids. I will just make a point that doesn't have to be the same person. You could have one person or persons that are the guardians and another that is actually in charge of the money for the kids' benefit. Because as long as they're minors, they can't take ownership or possession of that money.
Sure.
And so, guardianship is one of the big issues because, I was halfway joking a little while ago when I said the state of New Jersey, but put your hand, put yourself in the case of, you have a mom and a dad, they both passed. and they have minor children and they don't have a legal document that says who gets the kids as far as custodian goes. And that's where the state really does step in and make that decision. And many times that's a very difficult decision because you do have two loving sides of a family that would want them. Or I have seen a couple of cases where someone is next of kin, so they technically are the next of kin, but there's no way in this world that they would have wanted them to take care of the kids.
Right.
And so the biggest key is just have it set up and have it in writing. As long as someone is alive and competent, that can always be changed. There is nothing in a will that is irrevocable, as long as you're alive and competent and able to change it. It doesn't become irrevocable until one of those two things happens, and then you can't change your decisions. But so a will is the first big document. If you have children, I'm going to emphasize again, guardianship is the key there. The second document that I'll mention, and this is one where in my practice I see a tremendous amount, and this is a power of attorney for financial purposes. Okay. And so what this actually does is this is a legal document where you as an individual, you are naming who would be in charge of your assets or your things if you were unable to act on yourself by yourself, or even if you are able to act, that you're allowing to act for you. Now, let me explain what I mean by that. And there's two different types of a power of attorney. One is a durable power of attorney, and it's frankly the one that a lot of times we think of. And, as a planner, what I see most of the time is if I have a couple and there's a husband and a wife, they will generally name each other power of attorney. So, Jennifer, my wife, has power of attorney for me, which means that she can go and do anything of any asset that I own, that I have an interest in, any financial decision that I have an interest in, because I own a couple of businesses, I own some property, I own some things. So, like for example, my car is in my name. Okay. I went down to the DMV to get the car tag. A couple of things had not gotten transferred on the insurance yet, so they wouldn't give me the tag. And so I told Jennifer, I said, hey, I need you to go back down. This is like 3 or 4 days later when all that got changed. And she said, were they going to let me do it? I said, well, just take the power of attorney, because I have given her the ability to act on my behalf. And so the DMV, they took the copy of the power of attorney. They saw that she was who she said she was, verified all of that, and she was able to get the car tag, even though it was just in my name.
Right.
So that is a durable power of attorney and an example of where that can come into play. If you have someone that travels, someone that maybe is out of country, but they need to make a decision, they would be able to do that. Now, where it comes in more, where we see it is like, for example, I have power of attorney for my mother. Okay. And so if something were to happen to mom, then I would be able to act on her behalf to pay bills, pay property taxes, sign her tax return, do something with with a car, do something with a car title, with a car tag, things like that. Now, technically she's given me that durable power of attorney, so it is in place today. So one of the fears that sometimes people have is, oh my gosh, they could wipe me out. And with a durable power of attorney, in actuality, in most places, that's correct. So there is an alternate way to do a power of attorney, and it's what's called a springing power of attorney. And what that says is that I'm giving this person the power to act on my behalf only and only when I am not able to act on my own and am incapacitated, and there's a doctor that has said so. then that power of attorney will spring into action. And where we see this happen a good bit is if a mom has given a child power of attorney, or if, let's say, you've given your sister or your brother power of attorney, and because maybe your spouse is gone or something like that, or maybe there's a capacity issue with a spouse, so you want to give power of attorney to someone, but you don't want them to go be able to wipe you out, and so you have it as a springing power of attorney. It is still a power of attorney. It is still active. It's just that that's the way that it would become in force, if you will.
Hi everyone, I'm Cassidy, the second C in CMC Financial. So Dad sometimes gets on a roll with this podcast and might forget to remind you about a few things. 1, don't forget to like and share this podcast and leave a review. 2, follow CMC Financial on all of the socials, Facebook, Instagram, and LinkedIn. And 3, go check out the website at cmcfp.com. Okay, back to my dad. He's probably still talking.
So, quick story. My partner and I have a client who was in the hospital, and she was not doing well at all. It was approaching the end of the year, and she needed to make her required distribution from her IRA. And unfortunately, we were not able to talk to her because she was having some capacity issues. Okay. We said, okay, does she have a power of attorney on file? Unfortunately, she did not. And so our hands were tied. We could not do anything for that client because we can't just make a distribution without the client, asking for that. And the sister of this particular client, who was, trying to take care of all of her business and all that kind of stuff, her account was getting low and she wasn't able to really do anything. Well, she couldn't get any more money into the account because our hands were tied.
Sure.
Because we didn't have a power of attorney.
Right.
And so, there are real cases where that's a big deal. So, I will go back to you and I will say you need to make sure that you have that, because guess what? If, you're still alive, you're still breathing. So the will hasn't come into play at all, but the power of attorney does. Okay.
Okay.
Any questions so far? Thoughts?
No, a lot of that seems pretty straightforward. I did not know the differences between, or the different power of attorneys. I've just thought,
right.
For example, I'm the power of attorney for my mom, that if she becomes incapacitated, I'll be able to help her and be able to make decisions that would be able to help her wherever she's at. So,
So it sounds like you have a springing power of attorney for your mom.
Well, I'm not sure. I have to look into that now.
Okay. Well, it'll be very clear in the document as to if it's a durable power of attorney or if it's a springing power of attorney. It'll be very clear in the document.
The word durable seems to be popping into my head, that's what it is. So
right.
If she becomes incapacitated, then I, as durable power of attorney, there are certain things I won't be able to do on her behalf.
No, you should be able to do them. Now, the power of attorney also, and this, you bring up a really good point, is when you create a power of attorney, you're able to say, I want to grant this authority for these things.
Right.
And a lot of times it can be for everything. Or it could be that everything except, and I'll give you some examples on things that you might have an except on, except they wouldn't be able to change beneficiaries.
Right.
Or they wouldn't be able to create a trust, or they wouldn't be able to gift monies, or they wouldn't be able to, in some cases, sell property, or buy property, or invest in businesses. There are things that you can specifically exclude, or there are things that you can specifically include. One that I will tell you is becoming very, very popular, and most documents have this today, is to be able to have access to digital resources or digital assets. Now, when I say digital assets, I know we just did a couple of podcasts on Bitcoin and crypto and things like that. That's not necessarily what I'm talking about here. What I'm talking about is being able to get into email, being able to access online banking accounts, to be able to access a phone, having the code. You may remember a case several years ago with Apple where the government wanted to get into a criminal's phone and they weren't allowed to do it.
Right.
And so if someone passes away or someone becomes incapacitated, is it important that they're able to get into their phone many times, because that's where all of our passwords are stored? That's where all of our accounts are stored, things like that. If you can't get into someone's phone, then you have no idea what's there. And many people have a very digital footprint. And so there are pieces of a document today in today's world that allow you access to that digital footprint. Now, there may also be cases where you don't want anyone to have access to your digital footprint. And so you can also exclude in that respect. So these are things, and these are questions that we ask, a good bit around these types of documents. So it's not as cookie cutter as maybe you would think it would be. It can be, but it doesn't have to be. And this is just something that I like to bring up because it's something that we really never think about. 10 years ago, who thought of a digital footprint?
Right.
Yeah, but in today's world, so that's something I'll mention to listeners. If you've got documents that are, say, 5 years or older, you might want to go back and revisit, because they're likely not going to have some of the things in there that maybe you would want them to have in today's world. RJ, the last document that we typically talk about is what I call a medical directive or a medical power of attorney. And this is where, if I become incapacitated and, or let's say I'm not incapacitated, let's say I go to the emergency room and I can speak on my behalf. Okay. Well, my living will, my medical directive, my medical power of attorney, those names can be used interchangeably. If I can speak for myself, then I don't need any of that. But what if I go into an emergency room and I can't speak for myself? The medical doctors in most states, their job is to do everything they possibly can to keep you alive for as long as they can and make you as comfortable as they possibly can. That is their mandate. That is their oath. That is what their job is to do. It may be that that's not what you want. And if you don't want that, or if you want to have a certain religious right, let's say that, there's let's say you're Catholic, for example, and you want to make sure that there's a priest that's available. Your document can say that. Let's say that you are adamant one way or the other about organ donation. Your document can say that. I had a client one time that I was looking at a document, and this is the only time I've ever seen this, and I guess I can see both sides of this. She said, if I am burned more than 50% of my body, please don't do this and this and this and this and this. If I'm not burned 50% of my body, please do this and this and this and this and this. And so she was very specific in her document. And that's because in her world, she had an experience with a friend, and that had happened, and she wanted to make sure that didn't happen to her. So we all have things that happen in our life that sort of dictate the way our documents may be one way or the other. And here's what I'll tell you. There's not a right or a wrong way, but it's your wishes. And unless it's written down, then that's not necessarily going to be carried out. And so that's what that medical directive does, is that names the person or persons that would be able to act on your behalf or speak on your behalf. It's interesting on this podcast, we have Cassidy that comes on. She's my youngest daughter who does sort of our mid-reel for us. My Jennifer says a lot of times that she would never want Cassidy to be named as her person that could pull the plug, if you will, because Cassidy would plug in her phone and forget about what she unplugged. And so you want to be real careful about who you name.
Yes.
On that medical directive. Let me mention something as I begin to wrap here, and that is around beneficiaries. Okay. What a beneficiary does, and what has a named beneficiary is going to be any of your retirement accounts, insurance policies, life insurance policies, or you could have your bank account, your brokerage account, your individual account. You could have what's called a transfer on death or a payable on death. That's actually a beneficiary for a non-retirement account.
Okay.
And the way that this works is assets are first going to transfer by ownership. Okay. So if you own an account or you're on an account with your mom, it doesn't matter what her will says because it's going to transfer by ownership.
Right.
If you have a named beneficiary, it doesn't matter what your will says because it's going to transfer by beneficiary. I will caution someone if they've had a life change, if you've been through a divorce, if you're remarried, if you've had any sort of change in your family situation, please check your beneficiaries so that you don't have an ex named as beneficiary of anything. So that's important to do. But beneficiaries will trump any legal or any will documents. Okay. And so that's the first thing that I want to mention. The second thing that I will mention is, when you do name beneficiaries, what you're doing is you're naming your primary beneficiary. What that means is the next level of beneficiary. Then you'll see a word contingent beneficiary. So what that says is, let's say that, my mom has me and my two sisters as her beneficiary, and something happens to my mom and me, or I predecease my mom, something like that, but I'm a named beneficiary. That comes into what happens to my part. Okay. If there is not a contingent, then my part would go to the other beneficiaries, not to my lineage. And a lot of people think, oh, well, if I name my son, then it's just going to stay in his lineage. It's going to go to my grandchildren. Not necessarily. There is a word called per stirpes. It's a Latin phrase, which means in the lineage. And so per stirpes means that it would stay in the lineage. That is important to know. When you are dealing with stepchildren or step grandchildren, unless they have been legally adopted, they are not in the lineage. Now, if someone is legally adopted, they are in the lineage for estate planning purposes. So I just mentioned those because I've seen that come up a time or two. But I'll wrap up with this. If you're over 18, you own anything with a deed or a title, you have a child, or you're married, I believe that you need to have a will. I believe that anyone over the age of 18, and this includes a person at college, okay, should have a power of attorney and a medical directive. Because if you're, so I live in Alabama, 60+% of the students at the University of Alabama are from out of state, okay? A lot from the Northeast, a lot from the West Coast. If someone who's from New Jersey in school at Alabama, if that person needs something, mom and dad may not be right down the street in order to be able to do it. And if they're over the age of 18, mom and dad can't act on their behalf. legally, even though they're dependent, even though they still file them on their tax return. They need a power of attorney and a medical directive in order to be able to do certain things until they can get here and, be able to act on their behalf. So, so who needs that? I think anyone over the age of 18, and I think the same thing on the medical directive. So, I will mention, and I'll wrap with this. There are ways you can do this online. There are ways you can do it with an estate planning attorney. There are tools out there. Like we have a tool now through our firm where I can grant access to a client and I can guide them through some of the questions. They're making the decisions ultimately. But when someone leaves our office, because we have notaries and witnesses in our office, they're walking out with estate planning documents. So it's not as an arduous process as many times you may think, but you're at least getting the documents. Also, if you have changed states, please go back and relook at your documents to make sure that they're still appropriate in the states you live. We're going to do another episode in a couple of episodes, and we're going to touch on trusts because that's the second part of this that a lot of people are asking about. And so 2 or 3 episodes from now, just be on the lookout, and we'll do a full episode on trust, where they're appropriate, where they're not, different types, things like that. But I wanted to just kind of touch on some of the basics. I think we did this originally like episode 3 or 4. And here we are. I believe this is episode number 50. So it has been as one of my kids say, a hot minute since we have touched on that. And RJ, I will wrap with that. So,
well, before you leave, we need some contact information for you.
Well, RJ, as always, my direct number is 205-510-9074. Our website is cmcfp.com. We do have our income tax site for CMC tax is tax.cmcfp.com. And we talk a lot about estate planning and tax planning and all on both of those. And, that's probably the best way to get in touch with us. Then we also have our social medias, LinkedIn, Facebook, Instagram, our YouTube channel where this podcast is hosted.
Sounds good. All right. And most importantly, thank you for listening to the Financial Puzzle Playbook podcast. We ask you to share this podcast, rate it, and leave a review because this actually helped others find the show. Again, thank you for listening. And for Jim and everyone at Financial Puzzle Playbook, I'm RJ Malik, and we'll see you at the next podcast.